Hello, everyone. Good evening. My name is Diego Boz Martinez. I'm a professor, a law professor at the Universidad de Cádiz. But now I'm here because I'm the coordinator of the Asociación Pro Derechos Humanos de Andalucía, one of the organizations that are in the project of GR, Youth Education and Activism for Migrants and Refugees' Rights. This is it's not true. It's not the first time I was here in the presentation, but it's my first lesson. It will be not the last, because I will speak, I think, next Tuesday about European Court of Human Rights, and perhaps I will be here also for some of the roundtables. I'd like to make some warnings before starting. First one, I have just taught a class in Spanish of 2 hours, so now my English is a little bit rusty. If you have any question, the first thing is please to forgive me about my mistakes. So if you have any question in any moment, you can ask. We will.
Yeah, they can raise the hand, and they
raise the hand, and we will allow you to turn on the microphone, and you will ask orally any question in any moment. I prefer to make this presentation, this dissertation, as interactive as possible, even taking into account the number of participants we have. The second thing is that I have the time. We will have 45 minutes for the first part. So we will do a break for 10 minutes, and we will restart for other 45 minutes. So this is my presentation. It's a little bit more, it's wider than family reunification. So I will speak about family life of migrants in Europe, because I think speaking only about family reunification should be too narrow, and we will not understand adequately the situation and the legal framework, the framework of the situation of this issue. So as you can, I think you can see the index, the contents. We will start talking about the international framework about family life. The second point will be the right to family life under European Convention of Human Rights. I think these two first points will be in the first part of the class, and in the second part we will enter into the situation of European Union, talking about first of all about family life of European citizens. It's not exactly family reunification, but I think it's important to know, to understand the whole situation, and then family reunification of third country nationals. That in fact is the main point of this lesson. So the other warning I want to do is want to make is that it's the first time I have prepared this content for this class. So perhaps the timing is not adequately established. So sorry for if I take too many time. I will try to adapt my content to the division of time I I have explained before. In any case, I will start talking about the international framework of this point, and then for speaking about international framework, not a European Convention, not European law, the reference is the International Convention of the Protection of the Rights of all Migrant Workers and Members of their Families. This is the main legal text about this point. This was adopted by United Nations, by the International Work International Organization. So this was adopted in 1990, and it entered into force in 2023. So this text is very important because it established a system about members of families linked to the condition of worker of the migrant. This is a very important point that we will see in the next steps, that the link between family, between reunification, the right to have the family together, the person, is very related, very linked to the condition of worker. We are not talking two times. We are not talking about migrants' rights. We are talking about migrant workers' rights. This is based on the the vision of the states about the condition of migrants. You know, we are talking about migration, and the situation is that states try to avoid the entry of many people. So they established limits when they make the regulation of this position. And this is especially important when we are talking about international documents, international law, because these agreements, as this international convention, are very limited, because to make the agreement, to agree all the states, it's necessary to limit the terms, the content of the rights that we offer, that we establish, that we enshrined in the text. In this sense, the first limit is that this convention is only this convention applies only on migrant workers, so members of the families of migrant workers. But it's true that there is no there's a general clause that deny the possibility of discrimination. The convention obliges the states to make these rights without distinction of any kind, such as to sex, race, color, language, etc. So this is very important, because we are recognizing rights to migrant workers and members of their families in with this clause about the avoiding any kind of discrimination. So, but the problem for us is that if we watch the map about the status of this convention, we can see important evidence that no country in Europe has signed this convention. So European countries have not done any kind of legal steps about this convention. So you can see in this map I have got from the website of the International Convention that Spain, Italy, France, Germany, no European country has made any kind of tramit to adopt this convention. So this is not a text relevant in Europe, but it's our international framework. So in this sense, to establish a framework, we have to refer to the European Convention on Human Rights. This European Convention on Article 8 has recognized right to family life. This is a general recognition. It's not linked to the condition, to the situation of migrants. It's not as the International Convention that we have just watched. This is a general recognition, but this provision has been used by the European Court of Human Rights, the Strasbourg Court, to develop a very intense jurisprudence protecting migrants, protecting migrants' family life. This is very important. We will retake this point on the class on Tuesday, on next Tuesday. But as we have a lot of material about European Court, I prefer to take this point, to take family life in the class of today, today's class, to explain the content and the recommendations of a Strasbourg Court, Strasbourg case law about this point. Article 8, you can read it, is on the screen. Recognize private and family life as two different rights. There are jurisprudence of both of them, but its recognition is not an absolute recognition. This is not an absolute right. This is a very important difference. For example, Article 3 that we will talk on Tuesday. Article 3 is an absolute right. This is not an absolute right. This is a relative right. Why? Because the article, the convention, accept the possibility to establish limits to these rights, to this right. This is the second point of Article 8. In the second point of Article 8, as you can read on the screen, the convention accept the existence of interferences by public authorities when they are legal, established by law, necessary, and with a proportional vision. This is very important because those 3 points are the elements that the European Court has used to analyze the possibility of limit family life, of the possibility that states limit family life. As I have said, this is a general vision that is not only applicable to migrants. This is a general provision, but the fact is that the European Court has developed a very important jurisprudence, a very important case law about migrants. In this sense, this case law has adopted 2 points of view. The first point of view was a negative point of view. negative speaking about the right, not about the titularity, not about the content of the right, about the position of the right. I mean, this negative perspective consists in the right to family life was a limit to avoid deportations. So family life was established by the European Court of Human Rights as a limit to deportations. This is the first position. I mean, this is a negative perspective because the application of Article 8 was established not as the content, as the possibility of develop family life, as a limit to make an interference to family life. This is the first perspective. I will go deeper in next minutes, but this was the first point of view. The second point of view was a positive approach. It was more recent. It was a newer approach, and in this approach, the European Court considered the family life as, or considered the existence of positive obligations based on right to family life. Not only negative obligations, not only the avoiding deportation, also the allowing people to develop family life. In other words, not only avoiding get people out, also allowing people to enter. This is the position that the court adopted. I will go deeper with both points in the next minutes. When we speak about Article 8, about family life as a limit to deportations, we have to refer to some sentences. Perhaps the most important are Mustakin versus Belgium, Berhap versus France, and Uner versus the Netherlands. Mustakin was the first time that the court adopted this kind of position. The case was more or less that Moroccan national that has lived in Belgium from early age, from when he was 2 or 3, has committed a lot of crimes. Some of them when he was minor, and some of them when he was adult. The situation was that linked to these crimes, the decision of Belgium was to deport, to expose him to Morocco. And in this point, the case arrived to the European Court. And the European Court expressed that it was an interference to family life because all the family of Mr. Mustakin was in Belgium, also because he was living in Belgium from his early age. So it was his family, his right to family life would be affected if they take this decision to deport him. And the next point was analyzing if this interference was according to the second paragraph of Article 8. So if it was legal, in fact, it was legal because it was established by the law. The law established that when a migrant, when a non-national commits a crime, he can be expelled to his country. This was legal. If it was justified by one of the reasons that was in Article 8, in fact, it was justified, it was based on the reason of the national security. The avoiding crimes was linked to public security. So this decision was justified. But the other point was about the proportionality. So this was the point. It was legal, it was justified, but the relevant analysis was if this decision was proportional. So it looked forward this interest to avoid or to enforce national public security, but the court established a balance between this interest and the intensity of the violation, of the vulneration, of the interference in the right to family life. And in this analysis, they use some arguments. This argument was important by its relevance. So Mr. Moustaki was living in Belgium for practically his whole life. Mr. Moustaki has not any kind of family in Morocco. Mr. Moustaki didn't speak Arab, Darija. So in this decision, the court considered that deporting, that the expulsion of Mr. Moustaki was for the crime he has committed. So it considered that this balance was not fair, was unfair, and they reject the deportation. So it was the first time the court reject a deportation based on Article 8. It's very important because this argument. The other case you can see there is the hub versus France is a similar case, and UNER versus the Netherlands. The relevance of UNER is, in fact, that in this case, the court established the definition of the conditions that they will take into account in the balance. I have said before that the court made a balance in Moustaki versus Belgium, made a balance taking into account some elements. This balance was they made this balance in other cases, but it was very casuistic. So they was very linked to the case, and the circumstances that they had into account were different. In UNER, they systematized the circumstances, and they said what were the circumstances that they will take into account to this balance. And in fact, in general, they have into account the circumstances that we can see in this slide. But this slide, after having speak about the general or about the cases, the facts of the cases, we can make a general vision about the situation of this position of the court. The first point, for the court to analyze these cases, the first point was analyzing if the measure that the person reject is an interference with the right to family life, and the court considered that deportation are measures that consist in an interference with the right to family life. This is the first point of the analysis. The second point was there is a family life for the person. Can the person can the person or can the court apply the family life to the situation of this person? So they established that this concept of family consists in some kind of relations, not all the relations. First, marriage. When there is a marriage, there is a family life. Of course, if there is a divorce, there is not a marriage, so there is not a family life. This is very important. We have a lot of cases when the couple started, ended, restarted, and in this situation, the court, some cases consider that there is not a real family life, or there is a real right to family life. But this situation is also taken into account in the balance. Second kind of relations, of relevant relation, was a relation between parents and children cohabitating. So this is another important point. First, marriage, also the relation between parents and children, but only when they are living together. If they are not living together, they do not consider that there is family life, living together or living in a similar situation or living together. So when a situation of when there is a divorce, if there are some kind of right to visit, to live some days with the children. So not only living in a traditional marriage, in a traditional family, also another kind of family when there is some level of living together. And the other possibility are siblings. In this situation, is compulsory to live together. Only when they are living together, we can speak about family according the perspective of the European Court of the Human Rights, and when there is dependence. These two elements make the relation between siblings as a relevant family life according to Article 8, according to the vision of the European Court of the Human Rights. This is consequently, this is the first point. Consider that the measure is an interference, and also if there is a relevant family life to apply Article 8. As I said before, Article 8 is a relative right. So there are some cases when interference is allowed. When it is in accordance with the law, it's legal, as I said before, is necessary in the interest of national security, public safety, or economic well-being of the country, and for the prevention of disorder of crime, or for protection of health, morals, or protection of the rights and freedom of others. So in this case, when the deportation must be based on some of these reasons. It's true that the reason on which the state based the interference is relevant to the next point, which is the next point, the proportionality balance. So when the court considered that the measure is legal, so there is a law, a general law, a clear law, a previous law that allows the country to take this decision, to make this interference into the right to the right to family life of the migrant. This is the first point. The second point is this is necessary for the interest that Article 8, Paragraph 2 expressed. So national security, public safety, economic well-being, prevention of disorder of crime, protection of health and morals, or protection of the rights, when there is this interest. But the court considered that it's not the same. It's not the same, the prevention of crime, than the economic well-being. So the economic well-being is allows less relevant interferences. So when we are talking about most of the cases that the court analyzed were linked to prevention of crime. So it's the main case, as we saw before, speaking about Mustakin, speaking about Berab, speaking about Uner, speaking about Yanukovych. I think almost every case, all the cases that the courts analyzed were linked to prevention of crime. It's true that there are other reasons, but those reasons are less relevant, so the interference can be less intense. So this is this analysis. And in this point, I like to put on the table the principles that the court expressed to make this balance, this proportionality balance. In one plate, in one part of the balance is the nature of and seriousness of the offense committed by the applicant. So offense or offensive. This is how serious was the crime or the crimes that the applicant committed. It's not the same. It's clear that it's not the same driving after having driving drunk than trafficking drugs or murder. So there are three different crimes, so with three levels of seriousness. So this is the first point. In the other plate, that they put all the conditions, all the elements that are related to the family life of the applicant, of the person, of the migrant. First of them, length of the stay, how many times has the applicant been living into the country from he or she will be expelled, or she would expel him. So this is the first point. It's not the same that having arrived 2 years before, that living there from the early age, as we saw as we seen on we have seen on Mustakin case, the first case. So this is the first point. Other point to have into account, or the principle, the time that the time from the crime was committed until the decision to expel, and what has the applicant do in this time. This is another very important time, because the important point is not the same when there are a lot of time between the two points of reference, and the applicant can be considered as reinserted into society, has not committed another crime, and this is, in these cases, the proportionality, the balance was in favor of the applicant. Also, other point is the nationality of the persons concerned. In this sense, when the marriage is with a person, with a man or a woman, with the nationality of the country that pretend the deportation, it's harder to deport, because the partner of the applicant will feel a very high interference into his or her right to family life. So this is another point in reference. For example, in Mustakin case, there were two siblings that were from that has the Belgian nationality. In Berhab case, it was a marriage between a Moroccan and an Algerian person, Algerian migrant, and a French citizen, and also they had a young girl with French nationality. So this is another point to have into account. Also, the family situation, so the length of the marriage, other factors, other elements about about their family life. Also, the existence of children, and also the relations between the knowledge of the partner, of the spouse, about the condition of criminal of the migrant. This is a very a point to discuss. A very point. It's not clear how can affect to this proportionality balance if the relative knew or not the situation, or that the crime has been committed before, but the court takes that into account. Also, the existence of children and their age, and very important, the situation that will that better expressed, how can affect to the relative going to the country where the migrant should be deported. So because the court consider that there will be an affectation of family life of both members of the marriage, and at this point they say to continue their family life, there are two possibilities: allowing the migrant to remain into the country, or sending or going the relative to the country where the person will be expelled, where the migrant will be expelled. So they also analyze how this possibility affect the situation of their relative. As you can see, there are too many factors, too many principles, too many elements that they are of different intensity, of different seriousness, of different content, and also they project different consequences. So the result of these things, of those things, is that when we study the case law of the court, of the European Court of Human Rights about this right, it is an extremely casuistic case law. You can't predict what will happen with a migrant in this situation, because any principle, any factor could be highlighted by the court to establish the decision, its decision. So this is, there are no legal security, there are not a capacity to predict, to see before what will happen with him. And this is not a positive, this is not a good thing to say about jurisprudence, because you can see two sentences, and you can see that they have decided different different positions. They have adopted different positions, and you can't establish, you can focus on the reasons why they have decided in this situation. So this extremely casuistic approach is a very negative point. And there is another point, that now the court has started an approach, and we can say a procedural approach. So they are not analyzing the principles. They are analyzing if the country has taken into account the principles. So it's not a refutation of the content of the decision of the state. They are analyzing, they are studying the procedure of the decision. If the state has made this balance, even when the balance is considered not fair, is considered not well made, but if the state has made the balance, the court is tending to accept this kind of balance. So this procedural approach is very important, because we are not talking about the content of the decision, but the way in which the decision has been adopted. this is about the first point of right to family life under European Convention of Human Rights related to migrants. And the other point, the newest point, is family life in a positive approach. Family life producing positive obligations. In this sense, we can refer. There are 3 sentences, also 7 sentences. Perhaps BAC versus Greece is not family life, is personal life. It's a very interesting judgment. I recommend you to read it if you haven't done, because in this point the court expresses that the asylum system in Greece affected private life of asylum seekers, and they consider that the situation waiting for a decision too many times is against the convention. It's not the point today, but it's here because it's also they also put on the table the positive obligations of Article 8. For us, are more important Polidario versus Switzerland and Senego, Lunch, and other versus France. I think I have not many time before the break, so I will go into the content fast. So the main point is Article 8 implies also positive obligations, not only obligations of not doing, also obligations to do. It's not also limiting expulsion, limiting deportation, also to allow migrants to enter in a state. This is the content of positive obligations. It's a very, very, very important change of mind, because we, in this position, we can link family life to the obligation of the state about Article 8. It's true that the court said 2 things before. First thing, the state has a margin of appreciation of the interests involved. So it's not automatic. So the state can analyze the interest and has a margin of appreciation. And also the state maintains the right to control the entry and the residence of immigrants in their countries. This is the point of departure of the court. The point of departure are those points: a margin of appreciation and the right to control. But in this, even with this point of departure, they establish that the state can be forced to adopt adequate measures to avoid vulnerations of Article 8. For example, and to end this first part, we can refer to Polidario versus Switzerland. Polidario versus Switzerland was the situation of a couple between a Swiss man and a Philippine woman. In one day, the Philippine woman went back to her country. They had a child together, and the woman went back to her country, and she asked the father to allow the child to go to her country to meet him. But the father did not accept, make some kind of tricks to not allowing the child, and said that if you want to visit your child, you have to come to Switzerland. And Miss Polidario asked for a visa to enter into Switzerland to visit her child. And Swiss authorities, Swiss embassy, denied her visa. According to the economic well-being of the country and the possibility that she remained illegally in Switzerland, and the affectation about economic reasons, the affectation of the Swiss economy by she remaining in Switzerland. Obviously, it was a poor reason. A woman in Switzerland will not affect a lot the Swiss economy. And in this case, the Miss Polidario went to the European Court, and she considered that were a violation of her right to family life, because she couldn't visit to her child, and they have passed a lot of years from the last visit, and the court gave her the reason and considered that the Switzerland had to accept her to come into Switzerland. The way, as a familiar visa, as a temporal visa, any kind of visa, the way is not relevant for the European Court. But the important thing is that they have that Switzerland has to accept her. So this is another point, and it's very linked to family reunification. That will be the point for the second part of the class. We will take a break of 10 minutes.
Yes, sure. In 10 minutes we take a break, and next we'll start again.
Okay.
Okay. So I think we will start again the second part of the lesson. Can you turn off, Diego,
Yes,
the microphone?
okay, so I have 45 minutes for the whole, or I have to make some space for the questions?
Yes, actually. Okay. Okay, Diego, the floor is yours.
Thank you very much. Well, we will continue for the next minutes we will start the situation of the European Union. So we have spoken about international framework, about European Court of Human Rights. I think it's very important to understand the whole system, perhaps not the international framework, because as you have seen, no European country has signed the most relevant international convention of this point. But the European Court case law, the Article 8 are very important. I will come back on this argument in the future. So I will share the screen. Yes, sorry. just a second. I think here you are. Okay, yes. So before entering into family reunification directive, its content, I'd like to speak briefly about family life of European citizens. So it's not here. Sorry, just okay. Family life of European citizens. Family life of European Union citizens has changed in the time. So in the very beginning, when we speak about freedom of movement, this freedom of movement was related also to the situation of workers. In the first moment, the European Union was the European economic community, and it had a economic perspective, but it had only an economic perspective. So people were workers or were providers of services. So the right to the freedom of movement, the freedom of a state, was not linked to the condition of citizen, was linked to the condition of worker. And it's very important to take into account this argument, because we have seen before that this is the same situation that we live about international convention. But we can say how the situation has changed only reading the title of the law applicable. In 1968, it was the freedom of movement for workers within the community. Now, from 2004, it was the right of citizens of the Union and their family members to move and reside freely within the territory of the member states. This is the main point. This is the title of the directive, and it changed on 1992 because of the Treaty of Maastricht that started to consider European nationals as European citizens, and in this point, the freedom of movement that is linked to the condition of European citizen, Spanish, Italian, German, French, people from those countries can live wherever they want in the European Union. This is not true. This is the theory. There are some reluctances to this position, but in this sense, the important point for us, talking about family life, is that this freedom of movement of EU citizens is content in their own meaning, the freedom of movement of their family members. If the European Union considered that if they do not guarantee the freedom of movement of the family members, they are not guaranteeing the freedom of movement of the EU citizen. Because if the freedom of movement, the freedom of movement, the freedom of residence implies the separation of the family, there is not a real freedom of movement. Because of that, this consideration has a very important consequence, that is the freedom of movement, of the freedom of residence of the family members of a citizen of the European Union is not a personal right, is a derivative right, because it's not, I mean, the Colombian husband of an Italian woman has not the right to live in Spain because he's the husband of an Italian woman. He has the right if the Italian woman lives in Spain. So it's not a personal right, is a right derivative of the relationship. And it also implies that when the Italian woman doesn't live, ends her life in Spain and come back to Italy or to France, the husband doesn't maintain the right to live in Spain. So it's a paradoxical point, because we are talking about right of family members, but only as family members. This is a very important point when we speak about family life of EU citizens. The right of staying, the right of movement is not personal, it's only because they are family members. And there is also an important point. This regulation, this directive, will not apply to purely internal situations. So the meaning of that is that for the living of the Colombian husband of an Italian woman in Italy, this directive has not application. Only when the European citizen uses her right of freedom of movement, so when she comes to another country, the directive starts its application. This is very important because, excuse me, this is very important because this is a relevant limit. There are not a right to live with your family because you are an EU citizen, and there is not the right of your family to live with you. The only right is when you are crossing borders to another country, and when you are using your freedom of movement to avoid the limits for this freedom of movement, you can get with you, you can get with you your family members. So there are two very important points to understand the content of the family life of EU citizens. It's true that we do not speak about family reunification of EU citizens, but we can consider in some sense that the regulation of this situation is a family reunification. So if you get your family together with you, it's a kind of family reunification. the point is, this right is not of your family members, it's the right of the EU citizen, and it's not in your own country. You can only apply, or you cannot apply it, you cannot consider it when you are in your own country. You can argue about this, you can put it on the table when you are crossing, when you are in the territory of other countries. So this is a very important point speaking about EU citizen and family reunification. So as it's 7:30 and I'd like to end at 7:50 to have some time for your question, because my mate Laura Salzano said to me that you ask a lot of questions. So
Actually,
I will.
Yes, they do.
I
Last
will
lesson,
go.
they do a lot of questions.
I will go into family reunification.
Okay.
Family reunification, the last point of my presentation. Well, to speak about family reunification, we have to take into consideration three points of our legal framework. The first point in the European Union is the European Charter of Fundamental Rights. The European Charter of Fundamental Rights ensures in its Article 7 the respect for private and family life in the same content of European Court of Human Rights. This is the reason why I have explained before the European Court of Human Rights, because it's true that the European Union is not part in the European Convention of Human Rights, but the own European Charter of Human Rights, of Fundamental Rights, sorry, European Charter of Fundamental Rights has considered the European Convention as a relevant text, and the rules of interpretation said that to interpret this kind of article, we have to go to the content of the European Convention and the case law of the European Court. So, European Court of Human Rights. So, this is the first point. And after that, we have two directives. First, the main directive is the directive 2003-86 on the right to family reunification. This is the core of the regulation about family reunification in Europe. You know that directives are not directly applicable, so they have to be transposed by the state. And they make any kind of framework, and the state can adopt some decisions about that. So as we can see in a few minutes, the regulation is not a fixed regulation. They allow the state to design their own regulation into the framework that they offer. The other text, you can see it smaller because it's less important, is the Directive 2011-95, talking about asylum seekers, international protection. There are also the situation, they establish the situation of the family members of these people. So we start speaking about Directive 2003-86. the first thing is talking about goals. What, which is the objective of the European Union? Well, we can say that we find two objectives. First, this text is from 2003. If we see the different directive about migration, not about asylum, about migration, most of them are from the period between 2001 and 2005-6. After Tampere summit, the European Union decided that it's necessary to adopt a global, common system for migrants, not an identical system, but with some element of some common elements, and to harmonize the national legislation, the European Union adopted some directives. One of them was that this of family reunification. The own directive expressed that family reunification is a necessary way of making family life possible. It helps to create sociocultural stability, facilitating the integration of third country nationals in the member state. This is absolutely true. So family reunification is a very important point from different perspectives. This is perhaps a European perspective. So the host society, for the host society, it's important that people that can come with some relatives with a network to make their life better, because there are a lot of reasons about that. The own system of family control as an indirect system of control, the situation of the possibility to develop a best career, the possibility to establish more stable links. This is true. Also, for the people, for the migrants, it's important to be together, their family. But in some sense, we can consider that this is not true. This is a lie. So this is the goal, the objective that the own directive expressed, but the regulation is not in this sense, because most of the European regulation about migrants was designed to avoid migrants entering. Instead of considering that we are in an economical, social, demographical crisis, and instead of allowing people with relatives, with links with our countries to enter, the regulation puts lot of limits, lot of conditions to allow these family members to enter. The first point is to establish subjects. Which subjects can ask for family reunification? Which members of their families can enter? About subjects, the first point is that obviously, as the whole European regulation about rights, migrant rights, it's only reserved to migrants residing lawfully. So not for irregular migrants, only for regular migrants. This, in fact, not all the migrants, only those that holds a residence permit for a period of validity of 1 year or more, and who has reasonable prospect of obtaining the right of permanent residence. So this point has implied that the regulation of the member state has limited the possibility to ask for family reunification for migrants only when they are in the country for some period. 1 year, 2 years are the limits that the directive accepts. So if you enter into the country, except you are of a special situation, so blue card, so researchers in this, for blue cards, for researchers, they have their own system, but in general, for general migrants, it's necessary to be in the country for a period, for be legally in the country for a period between 1 year and 2 years before asking for the entry and residence of your family members. Which family members can enter? In this point, we have the first situation of different system. There are some family members that the state compulsory have to accept if they accomplish the conditions, but the state can open for other family members or not. The others are optional. The states have the option to accept or not the other members. You can see there spouse, minor children of the sponsor of her spouse, minor children of the sponsor when they have the custody and are depending on him or her, and minor children of the spouse when the spouse has the custody and are dependent on him or her. So this is the hard core of the family. The European Union states are only forced to accept this hard core. Only partner with a marriage, this is very important, partner with a marriage, and child with direct link. Optionally, the directive allows the countries, the member states, to accept other relatives, children of whom custody shared, first degree relatives, direct ascending, adult unmarried children, or unmarried partner. But it's not compulsory. The states have a margin of appreciation, a margin of decision to accept or not accept, not to accept individually each of them, to put into the national law the possibility for those people to ask or not for the reunification, for the entry and the residence in the country. So we can say that the concept of family member is very, very narrow, and the possibility to make it wider is given to the state. It's not a European decision. The decision is a state's decision. The other point, the last point about the directive are the conditions and the limits. I will not go into deeply in all the details of the directive. I have made the main concepts. So goals, subjects, and conditions and limits. Condition: the state may require accommodation, medical insurance, and resources. Again, it's not compulsory, but they allow the state to ask for the sponsor, is the term that the directive uses for the migrant to ask for the entry or the resident of its family member. I said the state can require the sponsor to prove that he or she has accommodation, adequate accommodation for the people that come into the country, have medical insurance when when in the country there is not public general medical insurance, and economical resources. So this is a very important limit to adopt, to use that disable the family reunification right. Also, the directive was in a moment when the Netherlands was very worried about the integration and started to ask for integration measures. So the directive accepts that the state can ask for the person to accomplish integration measures. So this is also an important point. The residence permit is that the person that came from other country to European country will be only until the day that the sponsor's residence permit expired. So this is an important point, because they are linked. The family member has not in the first moment a personal, has not their own, its own migration way. It's linked to the migration, to the sponsor, its sponsor migration way. But the directive established that when they are in the country for 5 years, they will get an autonomous permit. The relation, the legal relation between sponsor and family member will end in this point. About limits, there are limits on grounds of public policy, of public security, or public health. In this sense, the directive established that it's not possible to expel a person because he or she has an illness after the entry. So public health is limited. Also, the public health limit is limited by this point. The directive established the possibility to limit the access to the right to employ, the employment market, for 12 months. So the directive allows to avoid, allows to deny the possibility to ask for an employee of the family member for 1 year. This I will not extend on this, but for me it's very important about to understand the concept of the European Union. If you are entering as a family member, you can be, the state can prohibit you to work. Why? The only reason is because they are thinking that you are lying and that you are not a family member, you are a worker. But in any case, for every part of the relation is useless. So for the sponsor, the economic situation of the sponsor will be better if the family member works. For the family member, the situation will be better if he or she works, because we can. For the state, it's better to have people asking for unemployment working that person in her or his house doing nothing, going to the being on the street, or without an economic integration. So for the whole system, for the whole system, it's better that the family member will work, can access to the employment market. In Spain, for example, they do not apply this limit. They applied them for some years, and from I think 2011 they put out this limit. There are other limits. I am out of time. Only to finish, make a little reference about the directive 2011/95. Article 23 asks to maintain family unity of the beneficiaries of international protection when these family members are not beneficiary, and allows them to ask for the rights established between Article 24 and to 35, resident permits and right to education, right to employment, that because they are family members of beneficiaries of international protection. So sorry for the extension. Perhaps we have 10 minutes, 9 minutes now to some questions.
Yes, there are some questions in the QA from Abubakar. Why is this child of 18 plus isn't recognized as an immediate family?
Well, there are two situations for family, for European citizens. The limit is 21. It's a child of 21, but it's true that there are a point when the child is considered minor or adult, and the application is done when he or she is an adult. They can apply directly to family reunification. In fact, the things that are backwards of this directive is to avoid laboral migration passing through the way of reunification of family migration. This is as we can see before, why they not allow for family members to work, because they can't. Their obsession is to avoid a migrant to use another a false, not a false, because it's not false. You are not only one thing. You are not only a family member. You are not only a partner. You are not only a daughter. You are not only a parent. You are a lot of things. But but the obsession of the European Union of the States, it's to avoid the use of the family ways for laboral migration, and because of that, the measures were limiting some kind of family members as children more plus than 18 years. So, but well, it's true that it's important.
So thank you, Abubakar. So I have Lucia Hikes. She have a question, and I will allow her to make online. Go, Lucia.
Can you hear me?
Oh,
yes.
It's so weird. So I have a very personal case. It's a friend of my husband that I've been trying to help for a bit of a time. I'm not a lawyer, so I probably have no way to directly do what has to be done. But give me a second, honey. But I would definitely like to see what else or where else can I direct him. So he's Fijian, and he's a professional athlete. He came to France with a working visa. His wife and children are left back in Fiji because he didn't have the means to bring them the time he came. He's been residing here for about 2 years, and he's been denied family reunification according to the lack of resources. But I would like to know if there's a way to appeal to that, since he has a wage that's way over the minimum wage. And obviously, if maybe the first year or the first 2 years would be tight, but doable, then the wife could probably get a job, and then they could have a more dignified or more comfortable life. But is there a way we can appeal to a decision like this, knowing that he's actually got the resources?
Well, I can't listen properly to the question, but I think that you are asking for your personal situation in France about an application about family reunification that was denied. Every decision about family reunification can be appealed. This is a point the directive established. The point is that the national regulation is that you have to consider, you have to analyze the national regulation, because the directive establish the framework, but the particular conditions are established by the national regulation. So for me, my piece of advice is asking for some organization working on your territory. I'm sure that there are a lot of organizations with legal advisors about migration, to ask for the concrete details of your situation, and perhaps they will suggest you to start again the process or to appeal. But from my position, I'm sure that if there is a possibility to appeal, I'm not sure if you are in time, because there are time limits to appeal. If you have the possibilities to appeal, I mean the legal elements to appeal, the reasons to appeal, because the decision is unfair or not, I can't say that here. But the directive established a regime to appeal. Any decision about that can be appealed. But my piece of advice is asking for organization in your territory, but I'm sure that they can give you a more accurate solution.
Okay, thank you.
Sorry, thank you, Lucia. We have another question about Casey. Casey Hotto. She thank you for your lecture also, and she said, I do not study law, so my question may be a bit naive, but it seems to me that the limitation in the directive are very vague, which may mean basically open to interpretation. How does this translate or for the people? Do we have any data of the percentage of requests denied? Thank you.
Thank you very much. Well, I love figures speaking about migration. So, but I can't. I have searched for figures for that, but I didn't find any figures representing the situation of migration, of family reunification, of requests denied, and that. But I think it's a very important point. As well, in general, directives are open to interpretation because there are, as I try to explain, there are general frameworks. So those general frameworks has been filled up by the countries. So the important point are the national regulations. The national regulations can't be against this framework, but the details are on the national regulation. It's true that there are some lack of security, lack of legal security when we talk about this position, because when we speak about resources, when we speak about integration, so it's not clear what do they refer to, but it's a general situation of directives. And when we are talking about rights, and rights so important as family reunification, it's a hard thing.
Okay. So from Abu Bakar, we have a second question. Considering the digital era, if I meet someone online and we married, can she be recognized as a legal wife and allowed to come and join me?
Well, this is a national situation, so it depends on the national regulation. If the first point is your national, the law of your personality. So if you are from a country, you have to marry according to your law, and after that you have to take this marriage to the embassy of the country that you want to accept in this case your wife. And in fact, if you have a legal marriage, there are no reasons to deny this point. But it's true that in the process they analyze the consistency of the marriage. So I haven't said anything interesting. So it's very it's not clear. So you married according to your legal to your national law, and this marriage must be accepted in every country. But it's true that the directive establishes the possibility to deny the entry when they are when there are reasons to think that you are lying, and this can be interpreted in different ways, because digital marriage is not true, it's not fair. Well, but it has elements for being considered not fair.
Okay, so Natalie have a question. In the case of asylum seekers in Italy, for example, there is a long delay in response time. If while waiting for answers of their asylum application, the family decides to travel to Italy by their own means does family reunification work, or they should look for another way to regularize their situation?
Well, I'm not an expert about Italian legal system, so I'm Spanish. So in general, I can, when we are talking about asylum seekers, generally they come from countries in danger. So in fact, they can be considered also asylum seekers. So this is the first point. It's not usual that an asylum seeker from a country and their family members cannot be considered asylum seekers. But in any case, as a directive that I mentioned in last slide, they can be recognized their right to stay after the recognition of the international protection of the asylum seeker. So, in fact, there are not elements to deny the regulation, the regularization of the situation of the asylum seekers' family members because they are irregularly in the country. So for me, according to the Spanish system, not the Italian, but I think it should be the same, they can ask for their regularization after their sponsor, after the sponsor get the asylum seeker status.
Okay. So we have another question about from Penelope Elizabeth Gambi. I think it's about the limitation of the condition. What happens if my son daughter is disabled and it is 80 plus? Or what happens if I have a dependent brother, sisters with a disability? Can these people ask for family reunification?
As I tried to explain in my presentation, it depends on the country, and it's very hard because, as we can see, we are talking about son daughter disabled and with more than 18 years old. Well, for those relatives are in the second list, in the list of optional, not in the list of compulsory. So it depends. For example, most of the countries, for example, in Spain, the regime for this kind of situations is the same that for minors of 18 years old. It's the same, but it's not from the directive. It's a national decision. So it's possible for some countries to deny the possibility to ask for family reunification for this situation. The same for brothers and sisters. Brothers and sisters, it's even harder because brothers and sisters are not considered in the framework of the directive. If you have read the article, you can speak about minors, about children, daughter, son, about wife, husband, you can about relatives, about ascendant, but there is nothing about brothers and sisters. In fact, from a legal perspective, brothers and sisters are not members of the family. It's hard to end with this sentence, but in the sense of the family reunification directive, in the sense of most of the family legal frameworks in family national legal system, they are not considered family members. This is when we make advice with migrants. This is a point that shocks a lot. But for example, in Spain, you cannot ask for family reunification for brother and sister in any case. So it's impossible. So it's only for EU citizens. For EU citizens, there is the broad family concept. So this is other situation. But in general, for family reunification, is not possible.
Okay. I think we doesn't have more question. Okay. Thank you, Penelope. And if someone else has some question, they can raise the hand, but I think we have no time limit for that. Nobody. So I'll thank you everyone for being here tonight. Also, Diego, thank you for your lecture tonight and for the legislative framework from about the family reunification.